Random reflections on legal issues. The rules of the Arizona Commission on Judicial Conduct. Who really decides? This video is part of my ongoing personal reflections on legal issues and the way legal institutions operate in practice. It is not a legal conclusion, but an effort to understand how the system works, who makes the important decisions, and how much of that process is visible to the public. The rules of the Arizona Commission on Judicial Conduct. Who really decides? Before discussing how Arizona handles complaints against judges, there is a more fundamental question. What kind of wrongdoing is the Commission actually willing to examine? The answer is not as obvious as the name Commission on Judicial Conduct might suggest. At the beginning of its rules, the Commission explains that the Arizona Supreme Court adopts the Code of Judicial Conduct and that the Commission administers the judicial discipline system. Rule 6 identifies grounds for discipline, including willful misconduct in office, persistent failure to perform judicial duties, conduct prejudicial to the administration of justice, and violation of the Code of Judicial Conduct. At first glance, that sounds comprehensive. But consider what happens when a citizen complains that a judge ignored a mandatory rule, disregarded a constitutional protection, denied a litigant an opportunity to be heard, refused to address filings, or used judicial authority in an intimidating way. The first question becomes, is this misconduct, or will it be characterized as merely legal error? That distinction matters because Rule 16 allows dismissal of complaints that are considered solely appellate in nature, unsupported, frivolous, unfounded, or outside the Commission's jurisdiction. Who makes that first characterization? Rule 21 gives us the answer. It says, Commission staff shall evaluate each complaint received and recommend an appropriate disposition. That language deserves attention. Staff is not merely receiving mail, organizing documents, or checking forms. Staff evaluates the complaint, and staff recommends what should happen to it. That recommendation may include dismissal after the initial screening. But the public response does not necessarily reveal how that evaluation was performed. It never explains, allegation by allegation, why a particular issue was rejected, what rule or legal standard made that allegation ineligible for consideration, what evidence was reviewed, or how conflicting facts were resolved. For example, the response might have said, Allegation 1 is not subject to Commission review because certain rule excludes this type of issue. Or, Allegation 2 was rejected because the conduct described, even if true, would not constitute misconduct under certain rule or canon. That kind of explanation would allow the complainant and the public to understand the reasoning behind the decision. Instead, if the complainant receives only a general conclusion that the matter does not warrant further action, the most important part of the process remains invisible. What exactly did staff evaluate? What standard did staff apply? And why did each allegation fail that standard? Eventually, the staff recommends dismissal of complaints for the reasons unknown to anyone but staff itself. Then Rule 22 adds the critical consequence. Preliminary investigation is conducted on complaints not recommended for dismissal. So if staff recommends dismissal during this initial evaluation, the complaint may never reach the stage where the underlying facts are independently investigated. So the sequence can be very short. Complaint filed, staff evaluates it, staff recommends dismissal. No Rule 22 preliminary investigation begins. That can mean no witness interviews, no independent document collection, no factual verification process under Rule 22, and no investigative panel. In other words, the complaint may effectively reach the end of its substantive life before the formal investigation process ever starts. That makes Rule 21 one of the most important provisions in the entire document. Because the threshold question is no longer simply, did the judge do something wrong? It becomes, how did commission staff characterize what the judge did? And that characterization can determine whether anyone investigates it. Now compare what happens when a complaint survives that gatekeeping process. The rules suddenly become very detailed. The judge is entitled to due process and representation by counsel. The judge receives notice. If formal charges are filed, the judge receives time to respond. There is discovery. There is evidence exchange. There is exculpatory evidence. There are deadlines. There are hearings. There are rules of evidence. There is cross-examination. There is reconsideration. There is Supreme Court review. There is nothing wrong with giving an accused judge due process. A judge should have due process. But compare that elaborate protection with the position of the complainant. The rules expressly say, the complainant is not a party to the proceeding. That sentence may be one of the most revealing in the entire document. The citizen initiates the complaint. The citizen may possess the evidence. The citizen may have personally experienced the alleged misconduct. But the citizen is not a party. And there is no comparable procedural framework guaranteeing that the complainant's allegations will be factually investigated before dismissal is recommended. Then we come to Rule 23. Rule 23 says the Commission may act after reviewing a complaint, the report of the executive director or disciplinary counsel, or the recommendation of an investigative panel. That creates another serious transparency question. What exactly does a commissioner personally review before agreeing to dismiss a complaint? Does every participating commissioner read the original complaint? Does every commissioner review every exhibit? Do they examine the relevant court record? Do they independently determine whether the staff recommendation is correct? Or do they receive a staff-generated report and approve the recommended disposition? The published rules do not answer those questions. And that matters because the final dismissal order carries the authority and appearance of a commission decision. To a citizen receiving that order, the natural impression may be, the commission reviewed my allegations and reached this conclusion. But if commissioners have not personally reviewed enough of the underlying material to form an independent judgment, then a fundamental question arises. Whose decision was it really? Was it the independent judgment of the constitutional decision-makers? Or was the substantive conclusion formed earlier by staff and later adopted by the commission? The rules do not prove that commissioners routinely sign or approve dismissal orders without reading complaints. That would require evidence of actual internal practice. But the rules do create a system in which staff evaluation and recommendation occur before commission disposition, while the public has very little ability to determine the extent of independent commissioner review. That lack of transparency is itself important. Because an official decision carries meaning. It tells the public, this is our judgment. If the person or body adopting that decision has not actually reviewed enough of the matter to independently reach it, then the appearance of adjudication may be very different from the reality of the decision-making process. Whether a specific case would legally constitute fraud upon the court, misconduct, or some other violation would depend on actual evidence showing who reviewed what was represented, what was known, and how the decision was made. But the accountability question exists even without attaching a legal label to it. Can an official legitimately present a disposition as an independent judgment without personally performing enough independent review to make that judgment? That question becomes even more important when we remember what the rules themselves say their purpose is. The judicial discipline system exists to protect the public. Yet comparatively little procedural protection is devoted to ensuring that allegations from the public are actually investigated before rejection. By contrast, once the proceeding turns toward the accused judge, extensive procedural safeguards appear. Counsel. Notice. Evidence. Discovery. Hearings. Reconsideration. Review. The imbalance is difficult to miss. A judge deserves due process. But judicial accountability requires process too. It requires more than receiving a complaint. It requires more than screening it. It requires more than placing an official commission name beneath a conclusion produced somewhere inside an administrative system. True accountability requires independent judgment by the people legally entrusted with making the decision. Staff can assist. Staff can organize. Staff can research. But when staff is expressly authorized to evaluate allegations and recommend whether a complaint should live or die, that is no longer purely clerical assistance. That is substantive influence. And if commissioners then adopt those recommendations without sufficient independent review, the person whose authority appears on the decision may not be the person who actually made the decision. That is the deeper problem. Justice does not depend only on who possesses authority on paper. It depends on who actually exercises that authority. So after reading the Commission's own rules, the central question becomes very simple. Who really decides whether a complaint against a judge deserves to be heard? And perhaps the more troubling question is, how would the public ever know? When approximately 99% of complaints are rejected, transparency is no longer a secondary issue. It becomes the central question of accountability.